Lots of people get concerned when they start looking into estate plans because the whole thing is a big, complicated beast with many moving parts. So in this video, I'm going to break down what each part of an estate plan is and what it does for you. An estate plan consists of three parts: a will, a trust, and durable powers of attorney. You've no doubt heard of a will before. It's a legal document stating anything that you want done after you die. Wills are often wrongly seen as a document that determines who gets your property, but that's not actually the case. A will is meant to state any actions you want taken after you die. Symbolic gestures like whether or not you want to be cremated or have your ashes scattered at a specific place, things like that. You can designate where some of your property will go, but only things that are in your name at the time of your death. Wills aren't long enough to cover all of your earthly belongings. That's what a trust is for. Wills also have another weakness. They aren't valid until after you die, so to protect you and make your wishes known while you're still alive, you need durable powers of attorney. Durable powers of attorney are kind of like a will, except it covers any actions you want taken before your death. Generally, durable powers of attorney are legally recognized powers that you are giving to someone else to make certain decisions for you. Depending on the type, DPAs can kick in when signed or when the person signing is incapacitated by disease or injury. You need to set up durable powers of attorney and discuss your wishes with whoever you put in charge of your affairs so you can make sure that you receive the kind of treatment that you want. Not having durable powers of attorney set up leaves you extremely vulnerable to someone who knows how to manipulate the legal system for their own nefarious gain. This is meant to protect you from that. And speaking of protection, that's what a trust does, but for your property. A trust is probably the most special of the three parts of an estate plan, because in the eyes of the law, the trust is seen as a separate legal entity altogether, like it's a separate person. The way you use a trust is you take your property out of your name and place it under the protection of the trust. The trust has three different parties listed under it: the trustor, the trustee, and the beneficiaries. The trustor is the person giving their property to the trust. The trustee is the person who acts on behalf of the trust and carries out any actions stated within it. And the beneficiaries are the people who will ultimately benefit from the formation of the trust. They're the people who will assume ownership of the property in the trust. When people hear this breakdown, they often start to get nervous, thinking that a trust is a fancy legal way to steal your belongings out from under you by taking your property out of your name and placing it into a big thing you don't control. But actually, a trust does the exact opposite. A trust is a way to make sure nobody can steal your belongings in a fancy legal way. Although it technically takes your property out of your name, you still control it. While you're alive, you are the trustor, trustee, and the beneficiary. It's still your property, and you still get to do whatever you want with it. But then, when you die, the trustee becomes whoever you chose to be your trustee, like one of your kids or a trusted family friend. And the beneficiaries become whoever you chose to be the beneficiaries of your trust. Your kids, grandkids, a religious organization, a charity, whoever. The reason you want a trust is because when a person dies, the sum value of all their property is added up. And if it's over a certain threshold, the government takes your property to probate court, and the court decides how much they get to take. This is an extremely long and painful process that takes a year and a half at the minimum and ends with your loved ones needing to give up a huge percentage of their inheritance. And, oh yeah, all this is happening while they're still mourning the loss of a dear loved one. By taking your property out of your name and placing it under the protection of a trust, when you die, the sum value of your property can be kept below the threshold needed to take you to probate court, saving your family from all that grief. Because your property is now in the trust. And because the trust never dies, it never goes to probate court. With an estate plan from H&K Inc., you get the will, the durable powers of attorney, and the trust. And we'll see to it that it's properly implemented so your wishes are clearly stated and respected.